The much anticipated decision of the New South Wales Court of Appeal in Hochbaum and RSM Building Services was handed down yesterday in relation to Section 39 of the 1987 Act. Section 39 applies a 260-week limit on payments of weekly benefits in respect of a claim, unless the injury which is the subject of the claim has resulted in impairment of greater than 20% WPI. Now, the decision which was the subject of the appeal was a presidential decision in the Workers' Compensation Commission, which said that if weekly benefits had been discontinued under Section 39 and subsequently the threshold of greater than 20% WPI was satisfied, then the weekly payments entitlement arose from the date on which the threshold was crossed. The Court of Appeal has held that in those circumstances where payments have been discontinued and the threshold of greater than 20% WPI is subsequently satisfied, it's as though Section 39 never applied. So the entitlement to weekly benefits is assessed from the date on which payments were discontinued. So what does this mean? Well, it means that there's already a cohort of claims in existence which have satisfied the Section 39 threshold after being discontinued, where weekly payments will need to be assessed in arrears. It also means that going forwards, any claims that have been discontinued under Section 39, which subsequently satisfy the threshold, well, they will need to be assessed for payments in arrears potentially back to the date on which payments were discontinued. And what we're seeing is that whilst there's a limitation on a claim for permanent impairment being only one claim, there's a separation between impairment claims and threshold claims, which may enable claims for the threshold applying to Section 39 to be treated differently to a claim for permanent impairment. So what now? Well, it's possible that there will be an appeal or an application for leave to appeal to the High Court. I think that's unlikely. The other option is if the government sees this as an issue, they can legislate it away. Otherwise, obviously, we just need to make sure that our assessments of impairment in relation to Section 39 are sound and that we can maintain them in any subsequent potential challenge. I hope this helps.